Good afternoon. I'm Greg Monroe. I'm the interim dean of the law school. And it's my pleasure this afternoon to introduce to you the Honorable Susan B. Waters, United States District Judge for the District of Montana. She sits in the Billings Division. Judge Waters graduated, we're proud to say, from the University of Montana, I think in 1988. She went to Billings and established herself as a very accomplished practitioner in all kinds of areas. She clerked for the district courts in the 13th Judicial District. She was a criminal defense attorney after being a deputy county attorney. She was a civil and criminal litigation lawyer with a law firm in Billings, and then went on the district court bench. And she had a good long term on the district court bench as a well-respected judge. She was nominated to the United States District Court by President Obama in May of 2013, I'm sorry. She was nominated in 2013. She was confirmed in September of that year and went on the bench in December. And it's a great honor and a great source of pride for the Montana Law Review and the law school to introduce your moderator, Judge Susan B. Waters.
Well, thank you, everyone, for coming, and we have the slot immediately after lunch, so hopefully we'll have a stimulating discussion that will keep you all awake. And I want to thank the Law Review for inviting me to moderate the panel this afternoon, and also thank the University of Montana School of Law for hosting this symposium. As you can see from your program, our panel is titled Federal and State Conflicts, Preemption and Commandeering. So we, our panelists, are going to discuss and then ultimately take questions from the audience, that topic, and really the tension that kind of is between the preemption and commandeering principles. And just for a little refresher, preemption is the principle that is derived from Article 6, the Supremacy Clause of the United States Constitution, that a federal law can supplant or supersede any inconsistent state law or regulation. And commandeering is the principle that the federal government cannot compel states to enforce federal laws or enact or administer federal regulatory programs. As you all know, there are certain powers that, pursuant to the Constitution, are carved out solely for our national government, our federal government, and then other powers that which have not been granted to the federal government then go to the state governments, and then a few that are powers shared. For example, the exclusive powers of the federal government are to declare war, establish an army and navy, enter into treaties with foreign governments, regulate commerce between states and international trade, establish post offices and issue postage, and make laws necessary to enforce the United States Constitution. Then left to the state governments is they can establish their local governments, they can issue licenses such as driver's licenses, hunting licenses, marriage licenses, etc. Also think about licenses to professional people. They can regulate intrastate, within the state, commerce. They can conduct elections, ratify amendments to the United States Constitution, provide for public health and safety, exercise powers neither delegated to the national government or prohibited from the states by the United States Constitution. And then there are some powers that are shared both by the national and the state governments, such as setting up courts, creating and collecting taxes, building highways, borrowing money, making and enforcing laws, chartering banks and corporations, spending money for the betterment of the general welfare, and taking or condemning private property with just compensation. So it's kind of with that backdrop that we will proceed today with our panel. I'm going to first introduce Professor Robert Mikos. He is a professor of law and the director of program in law and government at Vanderbilt Law School. He specializes in federalism and criminal law issues. He currently teaches courses in federalism, constitutional law, federal criminal law, and drug and law policy. His most recent scholarship focuses on power struggles between the state and the federal governments and their implications for law and public policy, addressing issues ranging from marijuana legalization to immigration reform. So if you would all please welcome Professor Robert Mikos.
Thank you, Judge, and thank you to the law school here and to the Law Review for organizing this terrific event and certainly for including me in it. Today, I want to propose what is a relatively novel way for the states to curb some of what they perceive to be the harmful effects of the federalization of criminal law. Now, over the past few decades, a number of prominent jurists, policymakers, scholars have claimed that federal criminal law threatens the health of our federal system and threatens the interests of the states. The police power has always been one of those core state domains that Judge Waters mentioned to you earlier. But the growth of the federal criminal law, and there are now over 4,000 distinct federal crimes on the books, the growth of the federal criminal law has arguably limited the state's freedom to exercise that police power as they deem fit. Now, this happens in a number of distinct ways, but I think it's easiest to see when the federal government criminalizes some activity that the states allow. We see this in the field of marijuana, where a number of states, 23 states now, legalize at least some persons to use marijuana to distribute the drug, whereas the federal government continues to ban those activities. But we also see it in the field of sports gambling, where we have the Professional and Amateur Sports Protection Act that criminalizes gambling on certain sporting events, whereas some states, Delaware, New Jersey, and so on, would like to legalize that. We see the federal government prohibiting the possession and distribution of certain types of firearms. We see that are permitted under state law. We also see the federal government prohibiting certain types of abortion procedures. Partial Birth Abortion Act is a prominent case of this, that are allowed under a number of state laws. Now, the concern here, the states worry that these federal bans are going to prevent their residents from pursuing activities that they, the states, deem desirable. For example, that a federal ban on marijuana will discourage people from using the drug for medical treatment, that the Federal Partial Birth Abortion Act will discourage doctors from providing certain abortion services that the states deem to be medically necessary, that states like New Jersey, the federal ban on gambling will prevent people from spending money in their casinos and profiting the state through tax dollars, and so on. Now, the problem here is that the states can't stop the federal government from enforcing these federal bans. As I've argued in my earlier work, the anti-commandeering rule empowers the states to legalize things that the federal government prescribes, but it doesn't similarly empower them to block the federal government from enforcing its laws. That's called interposition or nullification. I use those terms interchangeably, and it's clearly illegitimate. Throughout our nation's history, there have been state officials throughout time who have, in various circumstances, claimed the power to block the federal government from enforcing its laws. For example, they'll pass a statute that says if a federal law enforcement agent were to try to enforce X law, well, that person commits a state crime, and we're going to throw them in jail. That's clearly illegitimate under the Supremacy Clause, under Cooper versus Aaron, all sorts of precedent to that effect. So the states can't formally block the federal government or obstruct federal prosecutions. So it's thought that the only thing that the states really can do at this point, the only option they have, is to implore the branches of the federal government to try to limit the reach of the federal criminal law. For example, to lobby the Congress, to lobby the president, to argue before the courts. And I want to acknowledge that this has had some effect. These sorts of lobbying efforts have had some effect, but many states believe they're not enough. So there are proposals now before Congress, for example, to legalize marijuana at the state level or at the federal level, or at least to defer more to state law. But no one thinks that these are going to be passed. And no one thinks that Congress is going to, anytime in the near or distant future, think more comprehensively about reform of the federal criminal law. There are instances where the executive has engaged in self-restraint, basically saying we are not going to prosecute certain individuals because we think that federalism requires us, or at least instructs us, to back off. Marijuana is a good example of this, where we've had 3 separate memoranda from the Department of Justice suggesting that the Department of Justice would not prosecute or might not prosecute some individuals who are in compliance with state law. But these are sort of isolated instances. They don't apply in all the different domains where the federal government criminalizes something the states allow. And it took a long time to get to this point. The most effective memo from the DOJ came out in 2013, fully 17 years after California first legalized medical marijuana. And lastly, the states can always argue before the courts and try to rein in federal power, get the courts to issue a constitutional ruling or maybe a ruling on statutory construction grounds. And again, that works sometimes, but I think I would disagree with Ilya's point last night. I am less optimistic about either the ability or the normative desirability of the court stepping in and reining in federal power over the criminal law. So far, I've painted a fairly grim picture. But today, I want to propose a different form of self-help, a tactic that the states could employ to try to curb the effects of objectionable federal laws. And the tactic is a simple one. The state could threaten or promise to pay for the vigorous legal defense of any resident who becomes the target of an objectionable federal enforcement action. And let me illustrate with a simple example. So suppose that a state legalizes medical marijuana and now wants to have someone to supply the drug. Well, the state could promise that someone that it would pay for the equivalent today of the F. Lee Bailey, of the great criminal defense attorney, that the state would promise to pay for that criminal defense attorney to vigorously defend that individual if they ever got in the crosshairs of some federal law enforcement agencies. This, I argue, is indemnification. It's not interposition. It's not nullification. And there is some precedent for it. The federal government, for example, currently under the Criminal Justice Act, pays for representation of some defendants in state cases when they're trying to get clemency under state criminal justice processes. And likewise, the states at one point returned to the favor to the federal government. There were northern states that passed personal liberty laws that engage in some forms of nullification. They try to block the federal government from enforcing the Fugitive Slave Act within their jurisdictions. But interestingly, some of those personal liberty laws also paid for the legal defense of individuals who are accused of being fugitive slaves. Again, on the theory that maybe this would help dissuade the federal government from coming in. I think there are 2 key benefits to this idea of indemnification. One is that it could encourage people to engage in federally prescribed conduct that the states deem beneficial. And that's so because one of the key sanctions that really attaches to any federal legal action against these individuals is the cost of paying for your defense, the tens, if not hundreds of thousands of dollars that you have to spend to defend yourself, not only against perhaps a criminal indictment, but also against civil forfeiture actions. So apart from defraying that important cost, which is not formally a criminal sanction but has the same effect, paying for one's defense or the defense of these residents could also deter the federal government from bringing these actions in the first instance. As we all know, the United States Attorney has very limited resources at his or her disposal. So the U.S. Attorney might think twice about bringing a case against someone they know is going to have a very well-funded defense from the state. And even if it doesn't discourage those cases from coming through, I think it's safe to say that if you spend more on your defense, you're likely to get better results. That at the end of the day, if you're represented by a high-profile attorney paid for by the state, you might get an acquittal at trial, you might get a better plea deal, you might get a better sentence, and so on. So one benefit here is that indemnification could encourage the conduct that the federal government wants to stop, but the state government wants to encourage. A second benefit is that this might actually help foster compliance with the state law. If there is some value to this indemnification, the states could make it a condition to receive indemnification that you fully comply with state law. In other words, the only people that the state is going to defend are those people who are not selling to minors, if we use that marijuana example, who are checking the credentials of medical marijuana patients who come in their doors, and so on. So if there's some value to this indemnification, it might encourage people not only to violate federal law, but also commensurately to comply with state law. And importantly, here, indemnification, unlike nullification or interposition, is a legitimate response to federal prosecutions. It is not preemptible. And the reason is that it is tied to a defendant's Sixth Amendment right to an attorney. In other words, I think it would be very difficult for Congress to say the state can't spend money to defend its citizens against a federal criminal prosecution because it implicates the Sixth Amendment to the Constitution. Now, I don't think this is any panacea. I don't think there's any panacea out there. A state can't guarantee its residents that they won't be the target of a federal criminal investigation or that they won't go to prison if the federal government decides to prosecute them. But I think this might help to push the federal government to respect state laws, to encourage non-enforcement of federal laws in those situations where the state really cares about the behavior at hand. I'll stop there, I guess.
Thank you, Professor Mikos. Next, I'd like to introduce Justice James C. Nelson. He is retired from the Montana Supreme Court. During his 19 years of service on the Montana Supreme Court, Justice Nelson has been a stalwart defender of the heightened protections guaranteed within Montana's Constitution. He is the author of numerous opinions and articles, and he has exhibited throughout his career a prescient understanding of the contours of the rights of an individual. In particular, Justice Nelson has contributed greatly to the understanding of an individual's right to privacy in Montana. A right, as stated in his landmark opinion of Grayson versus State, best interpreted as guaranteeing personal autonomy and the right to be let alone. Justice Nelson played an integral part in organizing the 2006 Browning Symposium here at the law school, which was entitled The Right to Privacy. More recently, he has been an advocate for gay rights issues and issues involving dark money in the judicial races. So I would like you to all welcome here today Justice Nelson.
Thank you, Judge Waters, and I too would like to thank the Montana Law Review for putting this symposium on. I've been a member of the advisory board for the Montana Law Review for a number of years and have worked closely with the students, and every year I work with these students. It gives me great confidence that the future of the bar and the future of the judiciary is in good hands. You know, when I'm put on a panel where everybody is a hell of a lot smarter than I am, I have two rules of thumb. First of all, I try not to say anything profound because I know if I try to do that, somebody will have already said it or written a book about it. So I stay away from that. The other thing I don't do is use PowerPoint, because I've found that artificial intelligence knows the difference between an idiot and an academic, and it doesn't cut any slack to the former. So I want to do two things today in the time that I have. First of all, I want to address the issue of the present state of federalism preemption and commandeering from at least my view as a appellate judge in Montana for a number of years. With respect to these cases, we don't get many of them at the state courts. Then that may come as a surprise or not, but we simply don't. Preemption, we get a few of those kind of cases, largely in the area of Federal Arbitration Act, Clean Water and Air Acts, Indian land use laws and jurisdiction, ICWA cases that was mentioned this morning, OSHA, Fair Labor Standards cases, FELA cases, and some Wage Act cases. So we do get those kinds of preemption issues. Not frequently, but we get a few of them. We get even fewer commandeering cases. The only one that I can even recall while I was on the bench was the Montana cannabis case in which the state raised a commandeering argument, which I disagreed with. I wrote a lengthy dissent on that, and it was a dissent, so you know what the majority decided. Interestingly, Judge Waters sat on that case by designation from the district court bench, and then Justice Morris was on the case as a Supreme Court justice. They were both elevated to the federal bench, and I was shuffled off into the retirement. So, so you can, I think there's a message for me in there. In any event, I disagree, and I'm sure probably most of you in this room are not going to want to hear this again, but I disagree that the states can legalize marijuana. I think under the principles that are set forth in the Arizona versus U.S. case, I don't think that states can authorize the possession, use, or distribution of a substance that is patently illegal under federal law. You can't comply with both state law and federal law. So I think under the Arizona case, I don't think that it is commandeering in the first place, and I don't think the state can legalize marijuana. That's not to say that I don't think there's a solution to this marijuana problem, though. And I think the solution is simply this. I think that the states ought to simply decriminalize and deregulate marijuana. Just say, we're out of the marijuana business. You do with what you want, and let the federal government deal with the ensuing train wreck. I suspect strongly that within a year of something like that happening, the federal government would be out of the marijuana business, and it would be back in the laps of the state where it probably belongs in the first place. We have come into other issues that impact federalism. We haven't dealt with really, I think, any of these in court yet, at least in cases that have come before the Supreme Court. The Real ID Act, this takeover of public lands that was discussed this morning. One issue that raises its ugly head every legislative session is the primacy of state law over federal with respect to federal law enforcement agents coming into a county. They got to check with the sheriff first. That's never gone anyplace. And then, of course, we always have the gun control people every legislative session trying to make inroads into laws, federal laws that deal with gun control. Last session, it was an attempt, as I recall, to try to accept any weapon that was totally made in Montana from the registration requirements of the Brady Act, and of course that didn't fly very well. The one commandeering case, incidentally, in gun control that truly was a commandeering case, and that went to the U.S. Supreme Court, was the Prince case that you're probably all familiar with, and that was a Brady Gun Control Act case, and that the commandeering principle was in fact applied in that case. So, to sum up that part of my remarks, I don't think that there's any real threat to the future of federalism or preemption or commandeering those doctrines. I don't think there's any real threat to those doctrines as envisioned by the framers of our Constitution, as those doctrines were set up. Now, I want to offer a thought further on this topic, given that the title of this symposium is The Future of Federalism, What Will Be Retained and What's Surrendered. This is probably going to be pretty controversial. And of course, you that know me would be shocked that I would say such a thing. But here's my thought. Let's add a couple of factors to this discussion that I don't think the framers thought about. The first is the rise in preeminence and power of multinational corporations. And the second, which is really a consequence of the first, and that is globalization. Let's assume, for the sake of argument here, let's just assume that Congress is being inordinately influenced, if not perhaps controlled, by big money. I say that because between 1998 and 2013, 20 businesses, most of which are multinational corporations, spent just shy of $5 billion lobbying Congress. When you add to that other corporate and special interest lobbying, the total spent is a bit over $39 billion. I think we're all familiar, those figures do not include the campaign donations made by large corporations, the campaign expenditures in the wake of Citizens United made by large corporations and special interests. And I think we're also probably familiar with the revolving door separating Congress and lobbying firms. And so what do these big spenders expect to get for their billions? Basically, they get to influence the government in a fashion that focuses on enhancing their bottom lines and their particular agenda. Ordinary citizens, the Joes and Mary Sixpacks of the world, don't fund these campaigns, especially since Citizens United. They are told what and how to fulfill those wants, who is going to provide for those wants, and unfortunately, like sheep, maybe lemmings, they simply go along. Corporate America does not want people to vote. Corporate America wants spectators and consumers. And while corporations are incorporated in the states, that doesn't mean that the states control what they do or how they do it. Indeed, the lines between public and private power have become so blurred that, especially with multinational corporations, states and nations have been stripped of many of their sovereign prerogatives. Multinational corporations are immortal, borderless super citizens, and in some cases, given their size and assets, even considered semi-states. You may think I'm overstating my case, but I do so on the good authority of a number of authors that have written extensively in this area in recent years. So, how do corporatization and globalization affect federalism? In my view, this is what happens. When mega businesses are pulling the strings at both the federal level and the state level, as I believe they are, the resultant laws and policies enacted by those to whom the strings are attached are a homogenized contrivance enacted not to enhance the health, safety, and welfare of citizens of either the country or the state, but rather are designed to enhance the profits and agenda of the mega money spenders. The separating and competing prerogatives of the federal and state governments as sovereigns are effectively sacrificed for the good of the business and special interests that are influencing inordinately the government. I don't think that preemption and commandeering are particularly relevant problems in that scenario because federal and state interests become, for the most part, almost identical. Nationwide media and marketing regurgitate the pap necessary, and pap rhymes with crap, incidentally, the pap necessary to keep spectators and consumers in the status of non-governing cogs in the wheels of the economy. I suggest that because of corporatization and globalization, the sharp principles of federalism that the framers envisioned will continue to morph into an amorphous fog having fewer and grayer definitions. Indeed, I suggest that we are entering that twilight zone now, and that while I won't be around to see it, and I expect probably most of you won't either, I think in 100 years the concept of federalism in this country will be an irrelevant concept. Thank you.
Thank you, Justice Nelson. Our next panelist is Professor Roderick M. Hills, Jr., and he hails from New York University, where he teaches a wide variety of subject courses, including constitutional law, federalism, law and policy, and land use regulation. Before coming to New York University, he taught at the University of Michigan Law School for 12 years. His forthcoming essay, Compared to What? Tie About and the Comparative Merits of Congress and the States in Constitutional Federalism, he tackles the issue of government subsidies for industry. In another upcoming book chapter called Sex, Drugs, God, and Federalism, Professor Hill examines the outcome of the 1648 Peace of Westphalia to determine the role that federalism played in diffusing conflicts over religion and culture. So please welcome Professor Hills.
So my only ambition is to finish in maybe 5 or 6 minutes. I promised the judge I would do that. I'm going to blab later on. If any of you want to attend that, would you sit on this side of the room? Because I have pretty PowerPoint pictures I want to show you. No bulleted text, but cool photos. So you won't be able to see them unless you sit over there. In any case, I want to talk very quickly about 3 problems of commandeering. I think commandeering is a really interesting concept. I'll remind you of the very basic law, and then I'll describe these 3 problems. They all deal with immigration law. And immigration law, as you know, is one of the most hotly controverted subjects in the United States today. And I think that these commandeering doctrines are designed to diffuse that controversy in useful ways. But of course, it depends on how you construe them, how useful they will be. Okay, so here's the basic rule. You remember this from basic con law. The feds are permitted to require states to obey generally applicable laws to which private parties are also subject. When such laws require states to provide services, money, information, precautions, that private parties must also provide. What are examples? Minimum wage. State governments have to pay minimum wage to their employees. State governments have to honor OSHA and safety requirements in the workplace for their employees. They have to enforce, informational mandates like posting hazmat notices for the public. It's just because private industry has to do that too. That's okay. Also, the feds can force states not to interfere with federal law enforcement. So if a Montana sheriff were to say to an FBI agent or a DEA agent, you can't arrest this marijuana dealer, I'm going to interpose myself, that would clearly be illegal. So the feds can force inaction from the states. They can tell the states, get out of the way. And they can also say to the states, look, everybody else has to obey this basic law of providing services, benefits, money to people in contractual privity with them. You do too. But here's what the feds can't do. They can't require states to enforce federal regulations. I want to emphasize that word, regulation, against third parties. So for instance, they can't say to a sheriff, we want you to arrest that person because they're disobeying federal law. Or sheriff, we want you to provide a background check for that person because we think they shouldn't be buying a gun. And so the distinction seems to be something like if you try to force a state to coerce, regulate, exercise sovereign powers over a private party, that's a no-no. But if you require a state to provide benefits or money to a private party or another person, that a private industry or a private organization would have to extend to the same kind of party, that's okay. Okay, that's the basic law. Here are the 3 problems really quickly. There's this basic rule in the immigration statutes passed in 1996 that says that local law enforcement has to allow police officers to transmit immigration information to the federal immigration authorities, to ICE. So suppose the feds tell New York City, look, you've got to allow your police officers to tell us, the immigration authorities, what the immigrant status are of people in their custody. Now, New York City had a policy. It said you're not allowed to communicate with immigration officials. And the reason is that they thought that really suppressed the willingness of the people in their custody to cooperate with city police, because they didn't, they might cooperate with the city police if they didn't think they're going to get deported. Can New York City say, look, feds, Congress, you're forcing us to put our personnel at your service. You're commandeering us. You're forcing us to regulate those people. Or can the feds say, no, we're not. We're just requiring you to provide information. And we require private parties to provide information about immigration status all the time, like employers have to fill out I-9 forms for people who are working for them. Okay, so that's the first problem. I think it's a difficult problem. Judge Ralph Winter of the Second Circuit upheld that in 1999, that mandate, but only on its face. And he said at the end of his opinion, in an as-applied challenge, where you showed that a particular police officer was moonlighting for the feds on New York City's dime during New York City hours, that might be different. Okay, second statute. 8 U.S.C. 1621 says states can't provide any grant, contract, loan, professional license to illegal immigrants. If you're a state, you're not allowed to provide benefits, contracts, money, licenses to illegal immigrants. Now note this seems to require that, say, if you're a state Supreme Court justice supervising bar admissions, that you have to ask about an applicant's immigration status and then take affirmative action to bar their practice of law if they say, hey, I'm an illegal immigrant. Is that commandeering? Or is this just sort of the mandate, like telling state officials to help, like private employers to fill out the I-9 once more? Or you're saying to the state Supreme Court justices, look, just as we require private organizations, to do something about illegal immigrants, we're requiring you to do so as well. Now, third program, and it's the mirror image of the program I've just described. President Obama's DACA program, the Deferred Action on Childhood Arrivals program, says that if you arrived in this country illegally but at a very young age, we are going to exercise as federal officials our prosecutorial discretion not to deport you or take any action against you. We're going to take deferred action. It's not that we're saying that you're here lawfully or not, you're here unlawfully, but we're going to turn our eyes the other way until we decide not to turn our eyes the other way. And, prosecutors can't go after every case. Prosecutorial discretion is a normal incident of being an executive official. Now, in addition, President Obama said, look, states, if we hand out DACA status to somebody who arrived here as a kid, you, the state, have to give them a driver's license, have to give them a position at state university, have to treat them just as you treat any other resident, because we tell you they're lawfully present for the purposes of work and other things like that. Could the state say, hey, this is just like forcing us to provide a benefit to a third party? And you can't force us to provide a benefit to a third party unless you would force, a private party to provide a similar benefit. So you can force us to provide minimum wage to one of our own employees, but you wouldn't force a private industry, to hand out benefits to just third parties unrelated to the business who are walking around on the sidewalk. You can't do that to us. So is that commandeering or not? I don't know. I do think this. My second my second problem, my third problem have to be treated the same way. Obviously, states like Michigan and Arizona, who've resisted President Obama's demand that they extend benefits to DACA persons, dreamers, so-called, obviously they, are operating from what we'd call conservative or anti-immigrant position. And obviously states that want to provide, say, bar licenses to illegal immigrants are operating from a more left or democratic position. Whatever the anti-commandeering doctrine is, if it's not neutral between those two, it's going to be discredited. I find all of these really close cases. I don't know how they should be answered, but I just want to close with this thought, and then if any of you have questions about this frontier problem in anti-commandeering law, I'll be glad to think about the thought with you. And that's this. The point of the anti-commandeering doctrine, and it dates from the 1840s and the Fugitive Slave Act, when the Supreme Court said you can't force state officials to enforce the Federal Fugitive Slave Act. The point of it is a sort of right of conscientious objection. The idea is to say, if there's a controversial federal policy about which the nation is hotly divided, state officials can fold their arms and wait and see if the feds can carry it out on their own. If that's the point of the program, is to somehow subject controversial federal programs to the acid test of whether the federal government will bear the cost of implementing them, then I'm inclined to think that all three of these policies should be resolved in favor of state autonomy. That's just my guess.
Thank you, Professor Hills. And our fourth panelist is Assistant U.S. Attorney Leif Johnson, and he attended the University of Montana here as an undergraduate, and he also graduated from the University of Montana School of Law. And from there, he took a position as law clerk to the Honorable Jack D. Shandstrom in the United States District Court Division in Billings. In 1992, he joined the United States Department of Justice and as an honors program trial attorney in the Environment and Natural Resources Division. Then in 1995, Mr. Johnson accepted a position as an assistant United States attorney for the District of Montana in the Billings Division. He became civil chief for the district in 2006, and earlier this year he took over as appellate chief. Over the years, Mr. Johnson has authored more than 70 appeals and argued before the 9th and 11th Circuits 40 times. Let's welcome Assistant U.S. Attorney Leif Johnson.
Thank you, Judge Waters, and thank you to the law school and Colin Phelps, Professor Monroe, Professor Burke for having me, and including the U.S. Attorney's Office in this discussion, which I think is an important discussion. As you may have gathered, I'm a Fed. Always been a Fed, worked my whole life. I'm a Fed. I didn't know I was supposed to feel bad about it until today, but no. Actually, you know, I have spent my career working with federal agencies on civil and criminal matters, and I've never seen a commandeering case, as Justice Nelson has rarely seen them, and I think they're very unusual. But we're here to talk about state and federal conflicts, and you know, one of the things that struck me when I started thinking about this was how many overt state and federal conflicts do we actually run into in the course of what we do every day in our office? Because we have interchanging responsibility, or our agencies have interlocking responsibilities with dozens and dozens of state agencies. You know, all of the federal land management agencies, the Indian tribes, and the various other regulatory agencies. And yet, in our ordinary practice in the federal courts, we rarely see cases that involve overt issues of preemption, and certainly not commandeering. And so I started to think about why that is. And I think it's a valid issue in the discussion of preemption. And that is, you know, for the most part, state and federal agencies have aligned interests. And for the most part, these agencies have an interest in getting along, not only for whatever reason is involved in a particular case, but for the future. You know, the Forest Service has an interest in getting along with the state DNRC because they're neighbors and they deal with each other all the time. And that's a healthy process. And I was civil chief for a long time, and I can count on one hand probably the times where we even considered raising the supremacy clause as a response to some sort of state action. To give you an example, we had a case where we had a rural postal carrier who was, as many of you know, they like to drive in the middle, you know, and so you see these guys and you're out there and you wonder who's driving that car, you know, and so the sheriff in Townsend pulled over our rural postal carrier and gave him a ticket for driving in a dangerous position in the car. And so the Postal Service was just up in arms. They called us. They're like, we cannot have this. You know, our drivers have to be able to drive from the middle. And the postal carrier was like, hey, you know, the regulation says I can do that. So you have this great preemption issue, right? I mean, postal regs, and you have the state, and, you know, let's go get them. You know, file a federal court case. We are going to establish the supremacy of federal law over the state. They must yield, because this is a very important issue for all of our postal drivers nationally, because they all like to drive in the middle, because then they can put the mail out easier. Well, it shouldn't come as any surprise that we were able to resolve that case. And thankfully, we didn't have to argue to a federal district judge that the supremacy clause ought to be invoked in a case involving a ticket over driving in the middle of a car, because eventually the county attorney, when he calmed down a little bit, and our office, when we calmed our client down a little bit, we're able to agree that, you know, it's probably not so bad if he can drive in the middle on the side roads when he's actually delivering the mail, but when he's on the main arteries, he ought to be in the left side. That was the agreement. No, preemption was preempted. So that's the usual case of the way agencies coexist across these various jurisdictional boundaries. And we have many of them on the criminal side. And you heard all about medical marijuana, and I want to talk a little bit about that. We had this voter initiative in 2004, and we're all aware of it. You know, all of a sudden, medical marijuana becomes legal. Well, and the problem in Montana, of course, was it was hard to understand just exactly what was legal and what wasn't. I mean, we had, as you know, I've got kids in school. It was a free-for-all. You know, we had dispensaries all over. We had lots of problems in the schools. We had cartels and gangs. We had money laundering, guns, potential for violence. We had all these issues, and it was very unclear just exactly what the state was authorizing with that statute. So our office jumped into that sort of breach and said, look, we can identify some real federal interests here. We can identify that it's bad, that we ought to have large-scale marijuana distribution with guns and money and distribution to people who don't even have cards and over, you know, pounds and caregiver-to-caregiver transactions. We can identify that those issues are essentially a federal interest, and by the way, they're really not in the state's interest to preserve them. So we structured the federal response to medical marijuana in a way that essentially didn't offend the state's interest. And I think for a large part that was a wise thing to do, because then it sort of took away the arguments from the other side, you know, that somehow we were precluding what the state had wanted to achieve with that legislation, which in itself was a very modest proposal. It was limited use of marijuana to treat serious medical conditions, which our prosecutions were not aimed at destroying or even getting involved in. And so I think that that is a useful template for people to think about federal and state conflicts. In the actual, when you get right down to the decision-making process, most of those conflicts are avoided. And I think they were avoided in the medical marijuana context. Let me just briefly respond to Professor Mikos about the idea of indemnification. Yeah, I've practiced in criminal cases for years, or there's some other criminal lawyers in the audience here. You know, it's pretty much my opinion that, you know, in the area of drug cases, I don't think it really matters if you have F. Lee Bailey or if you have the federal defenders. I mean, defending that case is just not very technical, or you're going to get a lot of more motions out of a private lawyer, but the result is probably going to be the same. And so indemnification, I think, might really be very limited in utility, and I have to wonder how much the state is going to be willing to pay to sort of preserve their sovereign interests in keeping the feds out of marijuana prosecutions. I just can't see in the end game that hiring private counsel is going to make a whole lot of difference. And then my final comment is on nullification. One of the issues that we see over and over and over in Montana, and it always makes me sort of shake my head, which is all of these statutes that the legislature you know, promulgates that purport to basically limit and nullify federal law. I mean, we've had a list of them lately, and we seem to get them every time around. Justice Nelson mentioned them. They seem to, well, they have no utility whatsoever. I mean, they raise the debate once again as to, you know, how much we actually cooperate, but I think they're corrosive to the process of federal and state cooperation, which I think is a very valid value in Montana that should be preserved. And with that, I think I will reserve the remainder of my time.
I'm trying to keep them all on track, and they're doing a good job. What we really hope to do with the remainder of our time, which is about 40 minutes, it looks like, is have some discussion among the panel members about some of these topics that they have raised in their opening remarks. And then, as I said, leave some time for questions from the audience. And I haven't moderated a panel before, so you'll have to bear with me, but it seems to me that somewhat of my role is to be a little bit of the devil's advocate up here to try to kind of get a discussion going. And so maybe I'll start first with our last presenter, Assistant U.S. Attorney Johnson. And we've talked a lot about in the realm of legalizing marijuana. And from your comments, Attorney Johnson, I think that you were basically saying that there aren't a lot of instances really where the federal government is going to try to, or they're going to try to not to step on the state's toes. There are very few where they would actually try to preempt the states and so forth in their laws. And there was some discussion in some of your materials, a discussion about how, for example, with the medical marijuana issue and legalizing marijuana now at the state level, and I believe 23 states, according to Professor Mikos, that despite the fact that all of that is still illegal at the federal level, that you've gotten at least one memo in 2013, you being the U.S. Attorney's offices across the land, basically telling you not to focus on people who are complying with the state laws with regard to their legalization of marijuana. And is that a fair statement?
Yeah, I think that's fair.
Okay. Yeah. And I mean, that's all very well and good so long as perhaps we have President Obama and some of the people in the federal government who are there now. But how can the states rely upon just, the whim, basically, maybe that's not the right term to use, but, or the policy decisions of people who are in Washington, only to turn around and have someone else in Washington who has a different policy outlook?
Well, I think as Justice Nelson was saying in his remarks, I mean, the problem is it is illegal generally, and even though we try not to step on the state's prerogatives in legalizing medical marijuana, that's not to say that another administration might change its mind. And, I had a close relative who was interested in getting into the marijuana business in Colorado, my brother-in-law. And, so not really a blood relative. And,
Is that your disclaimer?
Yeah. And I told him, I said, look, you don't know what the response is going to be. I worked for John Ashcroft, and as many of you know, I mean, in those days, it was very black and white in the Department of Justice about what's going to be prosecuted and what's not. And there certainly wasn't the type of nuance you see with this administration. And I think it is a valid question to ask, what might happen, in Colorado or other places where, they change their mind and they decide that, large-scale marijuana grows for the purposes of the recreational market are simply a violation of federal law, and they're going to pursue them. But right now we're not there, and thank goodness for me anyway.
But the law it remains on the books. I mean,
It
you
does.
certainly could prosecute, and so that's, I think, where the idea perhaps that Professor Mikos has is that as long as in states that have legalized marijuana, as long as the growers and suppliers and so forth are complying with state law, that they can feel fairly safe that they're not going to be prosecuted federally. But that is that's really a fiction. I mean, it depends on who's calling the shots, correct?
Well, I think I think Leif is right in that we shouldn't be overly concerned that the number of instances where the federal government is actually going out there and cracking down on people who are in compliance with state law is probably pretty small. But apart from the concern that the administration can change and the Attorney General can change and will change shortly, and that even an individual Attorney General could change his or her mind. The guidance that's been issued is non-binding, so a new administration comes in, a new Attorney General comes in, a new U.S. Attorney comes in. They could say, well, 2 years ago, we know when you were distributing pot, we said we weren't going to prosecute you or you are an unlikely target, but still within the statute of limitations, we changed our mind. What you did was criminal, and now you're going to pay the price for it. So there's a concern that non-enforcement just doesn't go far enough. The DOJ is unwilling to sort of bind itself and tie itself to the mast. There's also the concern here, it's not just that administrations change, but that U.S. attorneys are different. And we have 92 or 93 U.S. attorneys, and I think what the U.S. Attorney's Office here in Montana has done is commendable. I think the same goes for Colorado. But in California, and granted California is different, California is sort of the Wild West in this area of law, the 4 U.S. attorneys there have been very aggressive about cracking down, including cracking down against some operations that have been fully supported by local governments, Oakland, for example. So the non-enforcement, I think, is an important element of federalism. We don't want to myopically focus on the constitutional limits to Congress's power or what laws it's passed. We also have to look at what's enforced, but it's not a perfect substitute for other sorts of protections.
And of course, we've been talking kind of in the context of these medical marijuana cases, and I don't want to focus primarily on this criminal aspect, but I do have a couple of comments about that. I mean, that isn't the only example that we would have of where the federal government decides to prosecute people in situations that are not crimes at the state level. And for example, I'm thinking of the crime of a felon in possession of a firearm or any other destructive device that is defined in federal law. And of course, in the state courts, when someone is convicted of a crime and sentenced for that crime and then serves their time, let's take Montana, for example, then their rights are restored to them. And so they can possess firearms and do so without the fear of being prosecuted at the state level. But they are still violating the federal law because they are, if they've been convicted of a felony, they are felons in possession of a weapon or other destructive device that causes them to be in violation of the state law. Now, what interest does the federal government have in prosecuting a felon in possession of a firearm if the states have themselves determined that there's no public safety issue or any issue that the states would be charged with protecting their citizens from, and have determined that they want their citizens to be fully restored to their rights once they have served their sentence? And Leif, you can answer that, or anybody jump in. What federal interest is there in that?
But even in those cases, we have to evaluate a federal interest, right? I mean, the government is required in every case to sort of evaluate what the federal interest is before proceeding and what the state has done, what the alternatives to prosecution are. I mean, that's part of our regulations. And I guess my response on the felon in possession issue is that that statute was essentially a tool to take bad recidivist offenders out of circulation. I mean, that's what it was used for, and that's why you know, you have these various prosecutions where, you know, it doesn't come to light in the course of the proceeding what kind of threat this person might pose, but yet it would be part of the assessment of the federal interest to bring that case in the first place.
Can I say one thing?
Yes. Professor Kelson?
Go ahead.
No.
Okay,
Well,
Justice Nelson.
I was going to suggest, along with what Mr. Johnson said, was that, you know, there's a federal law, the Violence Against Women Act. It's a very important piece of federal legislation to protect women from violence. And inevitably, almost, especially in states like Montana, where everybody owns at least 2 guns, if there's going to be a partner or family abuse situation, there's very likely going to be a gun involved. And where guns are involved, people get hurt or killed. So I think there's a separate federal interest there that needs to be protected to uphold the federal law. Montana, states like Montana, gun states, pro-gun states, have been very slow in implementing those sorts of protections in family abuse cases. I kid you not, I can remember when I was a young attorney, it was a felony to kick a police dog before it was a felony to beat your wife, and I am not making that up. So if that gives you some idea about where that has come from, I think it's important that the federal law, the Violence Against Women Act to be particular, has a separate penalty. If that penalty wasn't enforced, I'm just afraid, at least from my own personal experience, both as a prosecutor and as a judge, that a lot of individuals, recidivist individuals, violent individuals who are getting out, have discharged their sentences, are going to get guns again, and the next girlfriend or wife or partner is going to get seriously injured or killed.
Okay, Professor Hills.
So I'm just going to be a little bit grumpy, and this is not to, personally reflect upon any of the very fine federal officials here, but for years I've been trying to get data. I had students try to get data. I've talked to federal officials at DOJ to try to test the following statement, which you will hear from prosecutors, from Harry Littman, from Jamie Gorelick, from all the classic DOJ prosecutors, from my brother-in-law, who was lifetime prosecutor. He's now general counsel for DHS. And he was chief of crimes and U.S. attorney at D.C. and deputy chief of public integrity. So I'd say, okay, Steve, I want a test of whether you guys really look at the, quote, federal interest in the U.S. Attorney's Manual. Because what you always hear is, look, I know that we can prosecute anyone who has anything. I mean, we can go after anyone with guns or drugs. And, we have to have these ridiculous nexus to interstate commerce, like the gun traveled in interstate commerce. Well, of course it did, or, the drugs. But we only use it against kingpins. We only use it against people who there's a serious federal interest. We don't go after the mules, the tiny guys, the boring guys where there's only a local interest. I say, okay, fine, prove that. I told you, I'm an important person. Well, do you have data? Well, no, I don't have time to get data. Why don't you get data? The Department of Justice will not give me docket numbers. We can't get pre-sentence reports. That's all confidential. Good reasons for that. But none of this has ever been tested. Now, anecdotally, if you talk to the Manhattan DA's office about what they think the U.S. Attorney's Office does in the Southern District and the Eastern District, they'll say they go after cases they can win. And that often means small fry. Often there is no real federal interest. Moreover, the U.S. Attorney's Manual counts as a federal interest the following, which I think is outrageous. If you can get a higher sentence for the federal crime that you can get for the analogous state crime, even though the state actually is a group of people with a cultural interest in a lower sentence, wants the lower sentence, it's a sufficient federal interest to go for the higher sentence. Now, I can't even imagine why that should be the case. I mean, if the people of Montana say, and I'm putting aside the civil rights interests, which the justice quite correctly has identified, but suppose we're dealing with a case that doesn't involve gender abuse or even guns. Let's say it's an ordinary drug case. And the people of Montana say, if you were a PWID case with small amounts of marijuana, we have no interest in putting that person away forever. And the U.S. attorney says, yeah, but I can get a conviction. It'll notch on my pencil case. It'll be great. And besides, the sentence is much higher under the federal sentencing guidelines. Why is that federal interest? Unless there's some other independent interest in punishing the guy because, for instance, that person's affecting people in other states, there's interstate spillovers, or that person is abusing federal civil rights, and we want to make sure that minorities who are protected by the federal government, are not injured, or they're injuring a federal facility, right? They're, smoking pot on a federal military base, whatever. If you can show that kind of federal interest, I understand. But if the stricter sentence is merely for the sake of a stricter sentence, that doesn't strike me as a genuine federal interest. But that's actually written into the U.S. Attorney's Manual. So my two complaints are that when federal officials tell me they only go after the big guys, but won't give me the data necessary to test that, to do a real regression, I have to shrug my shoulders and say, okay, I can't take it on faith. The second thing, and that doesn't mean that any individual U.S. attorney is not responsible. I'm sure that my brother-in-law and many fine U.S. attorneys do always look for a serious federal interest of the sort I described, interstate spillovers, so forth. But until I get the data from DOJ, and they are impossible about data. I mean, there's a guy in Syracuse, he used to be a New York Times reporter, who works with a statistician to try to call data. They have filed so many FOIA requests, hundreds and hundreds, are experts in litigating. So until the DOJ actually becomes a little more forthcoming in giving us data about what their patterns of prosecutions are, I'm inclined to treat these claims that they only go after big guys. They use their discretion after big guys with a grain of salt.
Can I?
Yes, we want a lively discussion. Go ahead, Mr. Johnson.
Very briefly, the federal interest includes the length of the potential sentence, but that's not the only factor, okay? So to be fair, it incorporates that as part of the overall larger view. I think we have a whole office of data in Washington, but I'm.
But you're not giving it up, no.
No, but he touches on a good point, which is, look, there are some of these cases like the handgun statute, where you can look at the face of the crime and say, it's just a guy with a gun who has a prior, right? And you may not be privy to all of the underlying thinking behind it because that's very private information. I mean, we don't share that, whether the guy has a mental disability, an issue, whether it's, in most cases that we see, an unbelievable rap sheet. And those are the kinds of cases we try to use that statute for. I'm not saying that there aren't some cases where U.S. attorneys go after the low-hanging fruit. That's probably the case. But I can say, and one of the things that everybody up here has seemed to ratify, is that we have limited resources, and with limited resources, we're usually trying to put our money where we could do the most, and that means not the little guy drug person, but the larger cases, and we seem to have this sort of idea that there's these plain vanilla drug offenders out there that are somehow, something that should be beyond the federal interest. I've never seen one of those, all right? I mean, in every one of these cases where we have at least substantial drug activity or, whatever, there's always a gun. There's almost always priors. There are issues of, all kinds of interrelated criminal conduct that is part and parcel of running a drug operation, and that's the reality of it. So we rarely have the small-time offenders that you hear, in the press. They complain about us, filling the jails with these people. I haven't seen those types of cases, and I don't think anyone in our office has. But I'm not to say they don't do that in New Jersey.
Justice.
I'm not going to make a long comment, but on this topic, there's a very good book, a recent book, that you might want to read if you're interested in this whole problem with marijuana and drugs and the war on drugs and the militarization of police and so forth that we've heard about recently. The book is entitled, it's written by a lady by the name of Michelle Alexander. The title of the book is The New Jim Crow, and it's a excellent scholarly book that discusses this whole topic. I think if you take the time to read that, you're going to have a greater depth of understanding about what America's drug problem is and is not, why we have a drug problem or we don't, and where we're at in this whole scheme of things. It's an excellent, excellent book.
Well, maybe kind of along those lines with regard to Professor Hill's comments about the disparity oftentimes between sentencings in state court as opposed to federal court, which, having been on the state bench for 16 years and now on the federal bench, there's a lot of difference between the sentences I would have given, for example, to a young individual in front of me with what we call personal use amounts of illegal drugs, as opposed to what perhaps the guidelines, the sentencing guidelines, which are advisory now, they're not mandatory anymore, but first off, I have to calculate what the sentencing guideline would be for that particular individual, and it is supposed to influence me, certainly, with regard to the sentence I hand down. Now, I'm curious to our panel members what you think about the fact that we had those sentencing guidelines and there are these disparities, and now we have an amendment, Amendment 782, which came out of the United States Sentencing Commission, which the Sentencing Commission is responsible for the sentencing guidelines and reviewing those guidelines and getting statistics and seeing how they're working and so forth and so on. And that amendment is applicable specifically to drug cases, and it is expected to pass in November. And what it does is that in drug cases, it reduces the sentencing guideline by 2 levels in drug cases, which seems to be some recognition by the Sentencing Commission, and the fact that it's unopposed, perhaps by Congress, that some of these drug sentences that have been handed down over the last, 20 years or so have been too severe, and certainly it's also an attempt to address overpopulation in our prisons. And again, not to just focus on criminal law, but I mean, it's an interesting issue here. I guess, first of all, what does anybody on the panel think about the idea that we adjust advisory sentencing guidelines in order to address prison populations? Does that seem like a reasonable rationale for lowering the sentencing guidelines? Anybody have a thought about that?
I guess
Professor Mikos, go ahead.
Maybe I'll take a stab at it, but of course with the federalism bent, which is my natural bent, I think to the extent that the federal government and federal judges start to sentence individuals and to take into consideration how they might be treated if charged in the state system, that could ameliorate some of the problems that we've identified here. I think we focus maybe myopically at the outset on instances where the states and the federal government treat the same conduct very differently. One criminalizes it, the other allows it. But there are lots of situations where the states and the federal government are both going to criminalize some conduct, but the states are going to treat it much more leniently. And I think Rick is right, and I've heard anecdotally, this is, to turn the anecdotes around, lots of people who work on joint task forces say, hey, the whole reason or the rationale we use for allocating cases between state and federal government is who gets the longest sentence. It doesn't seem to be sort of a sensible jurisdictional theory. It's just, who can get the most bang for the buck. So I think if that were incorporated into the sentencing process, it would be interesting. I mean, what the Sentencing Commission seems to be doing is just across the board, whether you're in New York or Montana or California, whether it's marijuana or heroin, we've been sentencing people for too long sentences, and I think I'm sympathetic with that view, but I think it could also be used in a more federalism context, that if you're in California and you are facing a marijuana case, that maybe that ought to be taken into consideration in a way it would not be in, say, my Tennessee.
Okay, anybody else have any thoughts on that?
Yeah, I mean, it would be kind of neat to have the following rule. I'd put it in the U.S. Attorney's Manual. The normal presumption should be that the federal sentence for any crime should be identical to the state sentence for analogous crime unless you can identify an interest of the federal government aside from having a higher sentence in a higher sentence. It just seems to me a very easy rule. And so the new sentencing guidelines would be whatever the state says. And some of those would be, well, the state's not taking into account the federal interest because there's some kind of interstate nexus, there's some kind of special federal civil rights interest, et cetera. But that would have to be in the PSR, I would hope.
Yeah, but of course, the states are all different, right?
good.
So you go to Texas, and you might get a heavier sentence than you would under the federal sentencing guidelines, and you go to New York, and it's a lot less. And that's the problem. Then that's the problem that the sentencing guidelines were created to address, which was, this huge disparity you see across the country for essentially the same conduct. I mean, you had, even in the federal system, you had judges that were, issuing, widely disparate sentences, and the federal sentencing guidelines were set up to at least bring some structure so that the variation would narrow in its amplitude. And, I've grown up and practiced my whole career with those guidelines, so I'm used to them. But I know that when they were first imposed, the judges were, it took a lot of getting used to. But that's what it was there for, and to reduce levels for drugs for seemingly the cynical purpose of reducing the amount of prisoners in our prisons, that's just a budgetary reality. And we in the department, we got educated on this smart on crime business recently, when the department rolled out this initiative, and the Sentencing Commission did, and the reality of it is that the Federal Bureau of Prisons is starting to eat up the entire budget, and it's kind of like Social Security. It's eventually just going to take over, and so there's no money for other useful programs for like dealing with problems in Indian country, or grants to state and local officers to hire more officers on the street. That stuff is gone because of the expense. And so, yeah, it's a result-oriented amendment to the guidelines, but at the same time, it really does address a desperate need in the federal system.
Okay, well, we have about 15 minutes left, and I do want to allow for some questions from the audience to our panel members. And as this morning, we have microphones that are circulating around, and I'll pick on you first, ma'am. Then we have a question right up here.
Thank you. You got it. Thank you. Thank you very much. My question actually is for Justice Nelson. I'm sympathetic to the concerns you raise about the influence of corporate influence in governance and the influence of money in politics. And so I can understand why you raise the concern that in the future, the conflict between state and federal power is going to be less important than this other conflict. But I'm curious to know more about why you think federalism might not be salutary in that context, in the sense that we often think of one of the chief benefits of federalism as the principle of regulatory backstop, that there's by having overlapping jurisdiction, and I think we can all agree that notwithstanding some areas that are clearly federal and clearly state, criminal law is a good example of a realm of law where there is a lot of overlapping jurisdiction. If there's a benefit to that, one of it is that it prevents, or it allows a sort of fluid dynamic of the expression of good governance at one level or the other when there is a problem of capture. And the problem you're concerned about is essentially capture of, perhaps you're worried about capture at both levels, capture by moneyed influence, capture of governance principles. But having two levels makes it that much harder for any one source to capture both of them at any given time. So isn't it beneficial to have sort of a stage in which there are two players that can be kind of used to support or even oppose one another when capture is a problem?
Well, I think regulation, I think regulation is extremely important. I guess my concern and my fear is, and I think that this has already been demonstrated to some extent, my fear is as the influence of corporatization and globalization get heavier and heavier and more pervasive in government, you're going to have less regulation because the government isn't going to want to regulate. And we saw this happen when free market economic theory came into the fore in, when was it, the late 70s, 80s. And the first thing that happened when the people that espoused that sort of an economic theory came into power was what they do. They got rid of the regulators. And that's happening now. What's the latest one I read? This isn't probably precisely on point, but it's kind of a good example. People in Washington State, I think within the last year or two, wanted to pass a citizens' initiative to find out if there were any genetically modified crops or products in the food that they were eating. And if they were, they wanted that disclosed, which seems to be, a reasonable request if that's what people want to do. Monsanto Chemical Company, who of course produces a lot of genetically modified stuff that goes into what you eat, came in and under the guise of political free speech that Citizens United opened the floodgates on, actually ran such a multi-million-dollar campaign against that citizens initiative that it destroyed it. So here you have the people wanting to regulate in some fashion corporate power in government, and yet because of Citizens United in this case, the corporation came in and just nullified that attempt to regulate. I think you're going to see more and more and more of that. So that's why I think that in the future, I don't know how long it's going to take. I think if something doesn't happen to turn things around, it's going to happen. I think the more corporations come into control of the government, the more money that flows into campaigns. This campaign money is the mother's milk of politicians. It just is. And you cannot run an effective campaign as a politician anymore unless you're getting money from some big corporate source, directly or indirectly. And the more you see that happening, a fortiori, you're going to have less regulation, less regulation, less regulation, and pretty soon, I don't think you're going to have much less separate sovereign prerogatives in regulation, federal and state. I don't think you're going to have either.
I do want to have one advertisement for New York City and one for New York City law professor Richard Bufault. New York City is a 6-to-1 match for public financing of campaigns if you accept the limits, which are fairly strict. It's unbelievably valuable. Most candidates do accept the limits because the public financing match of 6-to-1 is great. And Richard Bufault has a lovely article. He's a professor at Columbia Law School. He is now the chair of the Conflicts of Interest Board in New York City, but he's also an expert on election law and local government law. And he's a wonderful article detailing all the things that cities and counties have done to regulate campaign finance. They're quite aggressive. They have lots of public finance measures. And so I think Aaron is right to say federalism actually is critically relevant to campaign finance if you like that sort of thing. I express no opinion on the merits.
Yes, my name is Ron Newberry. I have my own law firm, and I had the pleasure of clerking for the Supreme Court and sometimes at the direction of Justice Nelson. That was an honor indeed. And a number of years ago, I think at a bar luncheon in Helena, shortly after the U.S. Attorney was nominated for the state of Montana, and Mr. Johnson's boss, and I think Justice Nelson, and Dana Jackson, and myself were there, and the issue about the conflict between the federal and state statutes regarding marijuana was very fresh because the state had just passed the initiative, and a lot of attorneys were representing those who were freshly into the business. And one of the practitioners in Helena stood up and foresaw this very conflict and asked U.S. Attorney Cotter what was the position of the federal government, given the fact that Montana had just legalized marijuana, speaking generically. And it's been interesting to hear Professor Mikos and you, Justice Waters, talk about these various memoranda that have stemmed from the Attorney General's office in Washington about just how this is going to be treated in the states where it's been legalized. And if I understood correctly, the recent memo sounded a whole lot like the first one, i.e. where states have legalized marijuana, we're kind of going to look the other way to some extent, up to I think there was even some measurement about how much marijuana might be involved, but up until that point, the U.S. Attorney was not going to prosecute aggressively. And so I might suggest that the state interest is almost sort of it might even be non-legal, in that attorney who posed that question went back, advised her clients, as surely rippled around the state about how we were to then advise our clients about just how deep they could get into this business and not run afoul of the law. And yet, not long thereafter, what appeared to me to be kind of a raining down on that industry ensued, and there are a lot of Montanans in federal prison. I don't see that same level of prosecution in Washington, and I was glad to hear there's some of it going on in California. But why doesn't the Attorney General and the President even warn those people? If you go too far, we're going to do the same thing there. Why aren't they prosecuting now? In Washington, in Colorado. The people I saw being prosecuted were those who believed in that policy, some from Missoula here, who are now in prison. They didn't look like gang members to me. They looked like people who legitimately, tried to further that interest. So I'm fundamentally curious why there isn't a level of prosecution going on in other states, as I observed here. And Mr. Johnson probably has the best insight as to the statistics that Professor Hills was looking for about who was prosecuted, who wasn't, and why. But in any event, I'll leave it up to the panel here to address those concerns.
And I think your concerns are exactly what we were talking about is, with the change of administration, there might be a change of policy. And there seemed to be a change of policy over the last period of years that you're talking about. Within the same administration, yes. So, Professor Mikos?
I think there was an important but subtle change. So the first memoranda that the DOJ issued, and I laud their effort in transparency, was extremely limited. This was the Ogden memoranda that came out in 2009 that basically said, if you use or simply possess pot, we don't care about you, and we never have. And that was pretty obvious. But it had very stark warnings for everyone who grew or distributed the drug. It basically said, hey, you're fair game. We tend to concentrate on the big guys, but you're all fair game. I think people misread that. A lot of newspaper editorials, including the New York Times, said, hey, the DOJ has just said, given the green light, and people didn't read the memo, but they read the newspaper reports, accounts of it, and the DOJ did a poor job of sort of managing the press afterwards. But then in 2011, a different Deputy Attorney General, James Cole, came back and said, we never said that we lay off distributors. But then in 2013, that was the first time that the DOJ said distributors who act in compliance with state law and local law, whether it's for medical or recreational purposes, just aren't a high priority. We could prosecute them, but we're going to look at these other federal interests. So I think there has been a change in the Obama administration that might explain why some people are in prison now, even though there was a DOJ memoranda in place. That was just a very limited memoranda, and that up until recently, again, 17 years after this all started, it's only been very recently that the DOJ has really seriously backed off.
Well, it sounds, Mr. Johnson, a lot like that case that Judge Christensen had, the Washington case, where part of some of the arguments on behalf of the defendants was that they'd relied on such statements as Professor Mikos is talking about and our questioner here to support their defense.
They made a whole host of estoppel arguments that Judge Christensen essentially denied. They were interesting arguments, but all of that guidance was carefully worded to try to preserve the inevitable possibility that there might be prosecutions in a particular area. But yeah, that's what there was an evolution during the course of this whole process. I mean, the state evolved and the federal response evolved. In particular, in Montana, we voters essentially changed the law, right? And so the system that we had, that we originally responded to, is just not present anymore. I mean, we just don't have the kind of, just out of control sort of distribution under the color of state law that we had recently. Now, I can't speak for Colorado, And, you know, and I do think that even the federal response in terms of how Colorado and Washington are going to handle this is probably different and has evolved some, maybe even the last couple of years. So, but I don't, you know, I mean, they don't tell me what they're investigating. They might be doing cases right now, but it does seem to me that the public response from the DOJ has evolved as the states have changed their laws. I mean, that's, I think, obvious.
We really only have time for one more question. We're about out of time. So, yes, sir.
Yeah, so on the
Just a second, we'll get you the microphone.
Oh, I'm
It's
sorry.
right behind you.
Oh,
And if you
sorry.
could identify yourself,
Hey,
please.
Ilya Soman, George Mason University. On this question of the statistics, I think this is a very interesting discussion that Professor Hills and Mr. Johnson had. We do have one set of statistics that may be relevant, which is that we know from the Bureau of Prisons that there are over 215,000 people in federal prison, and about half of them, or in some years slightly over half, are in there for nonviolent drug offenses. Now, I highly doubt, to put it mildly, that there's over 100,000 drug kingpins in the country, or even 10,000, and similarly that there's over 100,000 people who are causing significant interstate externalities. They might be affecting federal interest in some much more minimal sense, as you said. Maybe some of them use guns, maybe some of them had prior offenses, but this is really defining federal interest down, even assuming that we have a federal interest in the first place in waging war against our own people, which I actually highly doubt. But even if you are more favorable to the war on drugs than I am, it seems like this large a prison population couldn't possibly be explained by any kind of truly substantial federal interest defined as something states can't address or that causes big externalities or the like. But perhaps there is some other explanation for having this enormous population that is consistent with a theory of federal interest, and if so, I'd be interested if any of the panelists want to articulate such an explanation.
The memo doesn't say kingpin.
I know. I have commented on the memo extensively, and it does define federal interest down. There's even a catch-all at the end that there might be other federal interests other than the ones listed, and the U.S. Attorney can decide that they exist. So, yes, if the federal interest is defined as whatever is in a memo, then pretty much anything can be a federal interest. I agree with you there.
Well, I mean, it can change from one district to another, I suppose. I mean, depending on your decision makers. So, but yeah, I mean, the federal government, via the new sentencing guideline information, has acknowledged that the federal prison population issue is a big deal, and it's a real problem. And I don't know if this is going to address it. I guess we'll find out. But they're committed to doing this. The Sentencing Commission is committed, and it's going to create a lot of work for those of us who are working in the courts. And you know, we'll go through it one case at a time. But I think we're looking at several hundred in Montana.
Right. Judge Christensen anticipated there'd be about 250 petitions from individuals who'd been convicted under the drug laws that are in federal prison, just out of Montana.
And interestingly enough, as I understand, the judge actually has to, you know, sort of go back and readjust the sentence, but the judge you will have discretion, right? I mean,
That's
you
true.
can decide whether or not it's warranted in a particular case, because he might be somebody who has a lot of, you know, history that warranted the original sentence.
Right. There is some criteria that we'll have to examine, and we do have some discretion with regard to whether we would apply the 2-level reduction or not. Yeah. So it's going to be a lot of work. That's right. I mean, and that's just Montana. So think of all these other really large districts, how many people they'll have petitioning them. So, well, thank you very much. As you can tell, this is an interesting topic. I think a lot of interesting questions that we still could have, and I apologize there isn't enough time to hear from everybody who has a question. I'm certain that if you could get some one-on-one with any of the panelists, that they'd be happy to discuss some of these things with you. But I thank you all for your rapt attention, and I very much thank all of our panel members here today, and if we could give them all a round of applause.